Hello, everyone. Welcome to Court with Krissy. How can you forget this voice?
Not currently, no. I lost the job. I got fired. The bartender didn't like me.
Well, she's back for her plea and sentencing. It's swell. I hope you like it. Court with Krissy is now in session.
Who do we have from the jail? All right. Is that you, Ms. Brink, at the county jail?
Yes, sir.
All right, thank you. We're going to call your name, your case next, so let me find that on the docket here. All right, we'll call People versus Chelsea Brink. That's 25-43389-SM.
John Blair Brown on behalf of Ms. Brink.
All right, looks like we're here for, I'm sorry, Ms. Brooker, go ahead.
Oh, go ahead. Amanda Brooker appearing on behalf of the people.
Thank you. Looks like we're here for a jury status conference. Do we have a resolution, Mr. Brown?
Your Honor, I don't believe there has been an offer in this matter. I'll defer to Ms. Brooker in case there has.
There's not an offer.
This is a simple assault, Your Honor. I believe I sent something to the court on this matter. It is my understanding that Ms. Brink, if it is acceptable, will be entering a no contest plea for any potential civil liability.
I do see an affidavit of probable cause, but I do not see any other documentation that may have been sent to the court today. Is there something specific that you think you sent, Mr. Brown?
That is
I sent 2 pages that I believe.
Yep, I do see that now. Yep, I do see
what I sent.
All right, I just didn't know if there was something else specific that you had. So I have received those 2 items. All right, Ms. Brink, your attorney has said that he believes that you wish to enter a plea to the charge of assault and battery and plead guilty as charged. Is that what you want? Excuse me, plead no contest as charged. Is that what you want to do today?
Yes, sir.
All right. If you do that, you would be giving up your trial rights and you would not have a trial because you'd be telling me that you did something that was against the law. Do you understand that?
Yes, sir.
If you had a trial, you would have certain rights. So I want to tell you what those rights are so that you can make an informed decision. You have the right to have a trial by a judge or by a jury. You have the right to have the assistance of an attorney at that trial. You have the right to see, hear, and question the witnesses against you at trial. You have the right to call witnesses on your behalf and to get an order called a subpoena to require those witnesses to appear and testify on your behalf. You have the right to be a witness yourself or to remain silent. And if you choose to remain silent, that silence cannot be used against you because you have an absolute right against self-incrimination. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt and to have that burden of proof be on the prosecutor at all times. Do you understand each of the rights that I've just read to you?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
Do you understand that if you enter a plea today, that you would be giving up, waiving, and not having any of those rights other than you would continue to have Mr. Brown as your attorney?
Okay.
All right. Would you raise your right hand, please, so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, you can put your hand down. Has anybody promised you anything to get you to plead today other than what's been stated in court today?
No, sir.
Has anybody threatened you in any way to get you to plead guilty?
No, sir.
Are you doing so of your own free choice?
Sean John Conrad, he gave me a look.
I'm sorry, who gave you a look?
It's Your Honor.
Sean John Conrad, he did.
It's the victim in the matter.
How is that making you do
He peered
today?
He peered over the cop's shoulders when I was, and during the course of the interaction, he reached for a knife. So I was intimidated and fearful of him.
Are you talking about at the time of the incident? Or are you talking about today?
The time of the incident?
All right, I'm talking about today. Has anybody threatened you in any way to get you to plead guilty today?
Not today.
All right, is that time of the incident, are you telling me that you're acting today because you feel threatened today because of that previous incident?
In a way.
Well, here's the deal. If you're being threatened in any way, I'm not going to take a plea from you. You have to be doing this of your own free choice and free will. And if you're not, I'm simply not going to take a plea from you. I don't want anybody or you to feel like anybody is threatening you or doing anything that would take away your absolute choice in this matter. Do you understand that? All right. And now, in understanding that this is your choice and your choice alone, do you still feel that you're being threatened in any way to get you to plead guilty today?
I mean, I think the cop arrested the wrong person, but I don't feel like I'm being threatened necessarily. But I have nowhere to go if I'm let out of jail because Sean Don Conrady is still in my residence.
Well, we can deal with that later, but today is a day for whether or not you're going to plead. I can't solve all of your problems today. I just simply need to know that you're making this choice of your own free will and you're not feeling actively threatened today to make that plea. Is that true?
Okay.
That you're not being actively threatened today? All right. Then I will go ahead and continue with the plea. If you change your mind at any time, you let me know though, all right?
Okay. Thank
all right.
you.
So I'm going to ask you some questions about what you did. Is it true that on January the 5th of 2025, in Bagley Township of Otsego County, that you did make an assault or an assault and battery upon Sean Conrady?
Your Honor, this is a no contest.
I'm sorry, that's true. That's a no contest plea. I apologize, Mr. Brown. Thank you. And you have sent to me, Ms. Brink, do you agree that I can look at some paperwork to determine whether or not you made a plea, made an assault, so that you don't have to admit responsibility to that? Is it okay with you if I look at the police report and the affidavit of probable cause? All right, thank you.
Yes, go ahead.
Thank you for bringing that to my attention, Mr. Brown. I appreciate that. All right, I do find from the affidavit of probable cause that Chelsea Brink assaulted or assaulted and battered Mr. Conrady by punching him in the side of the head and neck with her right hand, and that there was a small red mark on the side of his head, and that this was an incident involving being upset about a DVD player and an Xbox cord at the residence in Otsego County, specifically on or about January the 5th of 2025. I do believe that that satisfies the proper factual basis for the charge. Any other questions as to factual basis, Mr. Brown or Ms. Brucker?
No, Your Honor. I believe there's a factual basis.
And do you believe that thank you, Mr. Brown. Do you believe that we've also complied with the court rule for taking pleas?
Yes, Your Honor. I'm sorry.
Yes, Judge.
All right, Ms. Brink, do you still want me to take your no contest plea?
Yes, sir.
And do you understand that a no contest plea, for all intents and purposes, is exactly the same as a guilty plea, except that I read the paperwork instead of talking to you about it? You understand that?
Yes, sir. Yes, sir.
All right. I will accept your plea. I do believe there's a proper factual basis, and I'll find that you did so knowingly, intelligently, and voluntarily. Let me catch up on my paperwork here. Mr. Brown, do you wish to proceed to sentencing right away?
I would like to, but I mean, there is a victim.
Probably can't without a victim.
I would have to defer to Ms. Brucker.
Judge, we have sent him some information. He doesn't have a working phone. We've not heard back from the information we've sent him. So if the court wishes to go forward, I don't have an objection to that. If the court wants to set it out for a week, I'm fine with that as well. And we can continue to attempt to get a hold of him.
I prefer to give him an opportunity, every opportunity to appear if he wants to do that. So let's set it out for 1 week. We'll come back on January the 30th at 1:30. Mr. Brown, do we need to address bond for your client, or are you satisfied the way it is?
Your Honor, I don't think we need to address it. She is actually sitting there on another child support matter as well. So regardless of bond, she is not going to be able to bond out.
All right. Ms. Brink, you understand that?
Yes, sir.
All right. So we'll be back in a week. You'll be able to tell me your side of the story at that time, and I'll hear from Mr. Conrad, if he wants to make a statement, and then I'll also hear from your attorney at that time as well. So we should be good to go. So I'll talk to you then.
Okay, thank you.
All right.
Get Mr. Ward.
Yes, please. Thank you very much.
All right, thank you, sir.
So just get it. Good afternoon. Are you Chelsea Brink?
Yes, sir.
All right, it's going to be just a minute. One of the staff members from the court is going to go run and grab your file. It was inadvertently left off the list to bring into court. So it'll be a minute and then we'll take your case. All right. So just relax for a minute.
Okay. So she already called them and they're on their way to
All right, Ms. Brink, are you still there?
Yes, sir. Yes, sir.
All right, I'm going to call your case. That's file 25-43389-SM. Chelsea Brink, set for sentencing today. I have received a, I'm sorry, go ahead, Mr. Brown.
Larry Brown on behalf of Ms. Brink.
Thank you. And Mr. Fortier is here, although I don't see him personally at the screen yet. There he comes back. I have received a victim impact statement. And I see, it's like an affidavit of probable cause. Do we have, this is date and time set for sentencing, is that correct?
Yes.
Judge.
All right. Yeah, that was allowed the victim to be served and to appear. Do we have a victim that needs to make a statement, Mr. Fortier?
I do not believe so, Your Honor. Ms. Weber's on, she can confirm.
We do not have a victim that would like to be present.
All right, thank you very much.
Yep.
So, allocution, Mr. Brown?
Your Honor, Ms. Brink has been sitting in jail right now. I believe at the last hearing we had, it was on the 30th for a sentencing. That was adjourned out a couple of weeks to have the victim present if they so desired, which apparently they don't. At that time, she had been sitting for 30 days. This is a 93-day misdemeanor. I don't believe there were any serious injuries in this particular matter. She's been sitting for 45 days. I would ask the court for time served in this matter.
She is she's being held by
Court staff is telling me that she's being held by the FOC. But if she's been in while this case has been pending, she'd be given credit for time served. Does somebody else have some additional information about that?
She is sitting in there on this matter as well as the FOC matter.
All right.
The FOC matter got adjourned.
All right, but you're still sitting on that case, though. Is that correct? You've been ordered to go to jail
No,
because of
they're
that?
not. No, they're not holding me on that case. They adjourned it to April 26th and they're not holding me. It says on the paperwork I received, it says that if I get out of jail and don't show up for my FOC case, then they'll issue a bench warrant, but they're not holding me on the FOC case anymore.
All right, so you would be eligible to be released if I sentence you today and release you today. Is that what you're telling me?
Yes, sir. And I'm just so you're aware, I am going to Sober Living, the Sober Living House, Billy Jane's Sober Living House.
All right, I'm going to give you a chance to more fully tell me about that in just a little bit, but I want to make sure that I've got the basic facts first. So, Mr. Brown, any other allocution that you wish to make?
No, Your Honor. She obviously, if she's going to Sober Living, she knows she has some issues she needs to deal with. That is going to be a good thing for her. And again, on a first offense, which I believe this is, a 93-day misdemeanor, she's already probably sat half that time.
Mr. Fortier, any other comments that you want to make?
No, Your Honor. I do note that 45 days for a case like this is pretty abnormal of a sentence. So I think time served with the court sentencing her to 45 days with time served for 45 days would be sufficient. And the victim has indicated he wants the no contact order remain in place. However, I understand that if there's no probation imposed, that there's really not a way for the court to enforce that after the fact, but.
And just for the record, Your Honor, I'm guessing at 45 days. It could be 42 or 43. I don't know the exact number.
39.
All right. All right, Ms. Brink, you also have the right to make a statement. The lawyers call it allocution, but basically it's just telling me what it is that you think is important for me to know prior to sentencing. Anything about yourself, your background, your history, your circumstances that you think I should know prior to sentencing you, and this is your opportunity. You don't have to make a statement, but you're welcome to do so. Go ahead.
Just that, I mean, I'm familiar with you, and this wasn't like a super. I mean, he wasn't seriously injured. I was acting in self-defense, really, to be honest with you. Like I said, I am going to sober living today. After sentencing, it's all been set up. I was accepted for a 6-month program. Which includes intensive outpatient treatment and 3 days a week and 3 days a week of AA meetings and whatnot. I was under the influence of alcohol when this happened, so I recognize that that's an issue, and I'm taking care of it.
All right. I have to say that you're accumulating quite the record, though. Which is
yes, I'm aware of that, but in my defense, I haven't been in trouble in 5 years. So,
well, that's good, but it goes all the way back to 2011, and there are some violent convictions on here: assaulting police officers, multiple convictions for that. You've had a dismissal of a domestic violence before back in 2014, so. I appreciate the fact that you are getting substance abuse treatment, and I think that's a very positive thing. I think the sober living is a very positive thing, and I recognize that 39 days in jail for a relatively minor assault, if that those words can go together, is out of the ordinary, but your case history is a little out of the ordinary too. And so let me just say this.
In my defense,
Ms.
all
Brink,
that happened.
Hang on.
Okay.
I don't need your defense right now. This is sentencing. This is the time. I gave you a chance.
This is my opportunity to talk.
All right. If you think you're not done yet, go ahead. Please finish.
Well, I'm just saying, in my defense, that all of my serious trouble happened between the years of 2017 and 2019. And I never assaulted a police officer, but I did resist arrest 5 times. And that's because I wasn't guilty of a couple of the crimes that I was accused of and should have gone to trial on them, but I was scared and didn't. And, you know, that's a me problem, not a you problem. But, you know, I never assaulted a police officer. I would never assault a police officer. I'm not that stupid. I may be dumb, but I am not stupid. So, but yeah, I mean, 6 weeks in jail for one very minimal contact with someone is kind of excessive. And you know, you can't really hold my rap sheet against me. You can only sentence me on the crime that is, you know, in front of you. So that's not fair to me.
I beg to differ with you. Unfortunately for you, I can look at your prior criminal history and hold it against you. That is you. That's your history. And past practice is a good predictor of future performance. That's how it is. So I'm not going to bury you because of your past history, but I do get to consider it in determining whether or not, in this particular case, what the specific sentence should be. So what I was going to say previously was that you're getting to the point where it's increasingly difficult for me to see the good person in you. it's getting increasingly difficult for me to say, okay, I'll send you to treatment and I won't keep you in jail.
I've never been
all
to
I'm really-
treatment.
Good. I'm glad
I've
that you're
never
gonna
even
go
been
now.
offered treatment. So
Okay, ma'am, nobody has to make you go to treatment. You could do that all by
I'm just saying
yourself.
I've never even been offered treatment as a solution.
All right, so now we're gonna do that. You're gonna be in sober living, you're gonna go to treatment. If you come back, don't expect me to say treatment's gonna be the highest priority. You understand what I'm saying to you?
No, I don't.
I'm probably gonna just put you in jail in the future. Your record's
Oh,
getting to
okay.
your record's getting to the point where I have to say the community needs to be protected from you. So use this opportunity wisely. You're going to get out of jail today. Hopefully I won't see you again and you'll never go to jail again. But your history
Right.
is such that next time I see you, I'm probably going to be thinking she needs to go to jail, not she needs to go to treatment. Now, do you understand what I'm saying to you?
Yes, sir.
All right. So as to the sentence today, I am not going to put you on probation. I'm simply going to give you fines and costs, and well, I'm going to leave the minimum fines and costs. There is a crime victim fee of $75 and a justice assessment of $50. Can you pay those within the next month?
No, sir. I'm unemployed.
You can't come up with
So,
$125.
and part of treatment is that they don't, like, I'm gonna be looking for, I have to be employed within 60 days. So, I mean, maybe give me 60 days, but I doubt I'll be able to pay it within 30 days.
I don't want to put you on probation. That's what I'm trying not to do.
Okay,
But I have to impose a crime victim fee and a justice assessment of so combined that equals $125.
Okay.
So I'm gonna give you 60 days to do that. Okay.
and where do
However,
I
if
pay
you don't,
that?
you're gonna pay that at the court, and you'll have the information when you get the paperwork from the court to do that. Okay, so you got 60
Okay.
days to make that payment. If you don't make that payment, I got to bring you back and put you on probation while you do that, and that's going to cost you some extra money every month that you're on probation to do that. All right.
Okay,
So I'm simply going to do crime victim fee and the justice assessment. I'm going to waive all other fines and costs. No probation. I'm going to put you in jail for, you said you were there for 39 days.
yes, sir.
I don't want that to be wrong, because if it's 38, that means you got to spend one more day if I say 39. So are you absolutely sure it's 39 days?
When I counted this yesterday, it was 39.
All right, I'm simply going to do this. I'm going to say 35 days and credit for all days previously served.
Thank you.
So hopefully that'll cover it. It won't be a problem. You'll be able to be released today. And I'll add to that, okay, to release today to 13/25. Anything else you would ask for, Mr. Fortier? Oh,
No, Judge.
Mr. Brown, anything?
No, Your Honor, thank you.
All right. The last thing I'm going to say, Ms. Brink, because you're not on probation, I can't stop you from having contact with the victim in this file. But do you understand that that's probably going to get you in trouble if you do have contact?
Well, I have to go to my house to serve him more paperwork because he's refusing to leave my house. And I also have to go there to get my clothing and toiletries and stuff to take to Bear River Health.
All right. Well, I'm not going to tell you what you have to do, but I'm giving you some advice. The more that you can stay away from him and have somebody else do those things for you, the better off you will be.
Right.
All right. That's all for today then. Good luck to you, ma'am.
Thank you.
You're welcome. Oops, here's. Thank you.